Hello, legal professionals and students. Welcome back to Legal Dwar. Today we'll explore the About IV, further issue of share capital. But before we dive in, make sure to hit that subscribe button and ring the notification bell so you never miss out on the latest updates. Companies may opt for a further issue of share capital under various circumstances. This could be driven by the need for additional funding to support expansion, investment opportunities, or to strengthen the company's financial position. Understanding the specific reasons behind further issuances is crucial for stakeholders. Example: in response to a significant business expansion that requires substantial funding, a company might decide to issue additional shares to raise capital and facilitate the growth plan. Legal and financial considerations before proceeding with a further issue. Companies must evaluate the legal and financial implications. This involves assessing the impact on existing shareholders, complying with legal requirements, and ensuring that the financial structure aligns with the company's strategic objectives. Example: companies must consider the dilution effect on existing shareholders when opting for a further issue. Legal aspects include obtaining necessary approvals and ensuring compliance with regulations. Procedures and compliance. The process of a further issue of share capital involves several key steps. This includes obtaining approvals from relevant authorities, determining the issue price, and adhering to procedural requirements defined by company laws. Example: if a company decides to issue additional shares through a rights issue, it must follow a structured process. This includes obtaining approval from existing shareholders, determining the issue price, and allotting shares within the specified timeline. Compliance with regulatory requirements. Companies engaging in a further issue of share capital must ensure strict compliance with regulatory frameworks. This involves obtaining approvals from regulatory bodies, making requisite disclosures, and adhering to guidelines set forth by securities commissions or stock exchanges. Example: in India, companies planning a further issue of share capital must comply with the regulations of the Securities and Exchange Board of India, SEBI, and other applicable legal provisions. Understanding the intricacies of further issuances is essential for companies seeking to optimize their capital structure and investors evaluating the potential impact on their holdings. In the subsequent sections, we will explore specific mechanisms such as private placements, preferential issues, and rights issues, each with its unique considerations in the context of share capital. Special cases of share issuance. Private and preferential basis. Private and preferential share issuances are unique mechanisms through which companies raise capital. Understanding the distinctions between these two methods is crucial for companies seeking strategic investment and investors evaluating these opportunities. Example: a private placement involves the direct sale of shares to a specific group of investors without a public offering. On the other hand, preferential issue entails the preferential allotment of shares to a select group of existing shareholders. Legal framework for private and preferential issuance. Both private and preferential issuances are subject to specific legal frameworks to safeguard the interests of investors and ensure transparency. Companies must adhere to regulatory requirements and obtain necessary approvals before opting for these modes of share issuance. Example: in India, the Companies Act and SEBI regulations outline the legal framework for private placements and preferential issues. Companies must comply with disclosure norms and ensure a fair and transparent process. Rights issue and bonus shares. Rights issues offer existing shareholders the privilege to purchase additional shares at a discounted price before these shares are offered to the general public. This section explores the dynamics of rights issues and their significance in corporate finance. Example: if a company announces a rights issue of 1 share for every 5 held by existing shareholders, an investor with 100 shares can subscribe to 20 additional shares at the discounted rights issue price. Concept and distribution of bonus shares. Bonus shares, also known as scrip dividends, are additional shares distributed to existing shareholders without any consideration. This section delves into the concept of bonus shares, the reasons behind their issuance, and their impact on shareholders. Example: if a company declares a bonus issue in the ratio of 1:1, shareholders receive 1 additional share for every share held without any payment. Understanding these special cases of share issuance provides insights into the diverse strategies companies employ to raise capital and reward shareholders. In the subsequent sections, we will explore employee stock options, ESOPs, sweat equity shares, and the intricate processes of issuing and redeeming preference shares. If you found this video helpful, give it a thumbs up. Don't forget to share it with others who may benefit, and consider subscribing for more valuable legal insights.